Hello and welcome to this latest housing webinar from 42 Bedford Row. My name's Iris.
My name's Jamie.
And we are going to talk to you today about antisocial behaviour injunctions, and particularly about the paperwork that you need to prepare when you are starting an application for an antisocial behaviour injunction. So Jamie, I thought it might be good if we started with just a quick trot through what the law says about antisocial behaviour injunctions before we get on to the practicalities.
Okay, that sounds good. So you're going to tell me then, briefly in terms of the legal test, what the circumstances are in which the court has the power to grant an injunction.
Yes, that's section 1. Right, very first section of the Antisocial Behaviour Crime and Policing Act 2014. And there are 2 conditions for granting an antisocial behaviour injunction. Number 1, the person has engaged in antisocial behaviour. And number 2, the court has to consider it just and convenient to grant the injunction in order to prevent that person from continuing to engage in antisocial behaviour. So that's it, that's the law.
Okay, so the obvious question there is, what is antisocial behaviour?
That is a good question, and you might think that it is a really high bar, but actually section 2 of the 2014 Act is surprisingly broad. There are 3 elements and any of them is enough to amount to antisocial behaviour. So it's an either or. It's either harassment, alarm or distress, either actually caused to somebody or likely to be caused to somebody. That is the higher burden of proof. The lower burden of proof, and this would be sufficient to amount to antisocial behaviour, is behaviour that is capable of causing nuisance or annoyance. Just capable, not actually having caused it, but even just capable of causing it is enough. And that is either housing-related nuisance or annoyance to anyone, or if it's not housing-related nuisance or annoyance, it can be nuisance or annoyance to a person in connection with their home, in connection with their occupation of their home. So those are all different types of antisocial behaviour that are listed in section 2 of the Act.
And thinking about what you said there actually is interesting, because in this context there are obviously quite often issues that can be very serious, sometimes of a criminal nature or appear to be of a criminal nature. But what is the test in terms of these proceedings? They're civil proceedings, aren't they? So is it, what's the burden of proof? Is it a civil burden of proof? Is it a criminal burden of proof?
It's a civil burden of proof at this point. Now, if you were talking to me about breaches of antisocial behaviour injunctions and talk about committals, then we would be talking about a criminal burden of proof in relation to the proof of breach. But at this stage, we are simply talking about whether an injunction is going to be granted. That is a civil question, civil burden of proof, balance of probabilities.
Okay, very clear. So in terms of types of injunction, we can have, obviously, we can have mandatory injunctions or we can have prohibitory injunctions. In the context of antisocial behaviour injunctions under the 2014 Acts, under the 2014 Act, sorry, what's the difference in terms of approach legally? What do you have to show?
Well, let's start with what is a mandatory injunction and what is a prohibitory injunction. Prohibitory injunction is what you would normally think about. It's you are forbidden from doing X, Y, and Z.
Yes. That's
prohibitory injunction. And in order for the court to grant a prohibitory injunction, it's what we talked about. Is there antisocial behaviour? So that test, harassment, alarm or distress, or capable of causing nuisance or annoyance. And then if the person has engaged in antisocial behaviour, is it just and convenient to grant the injunction in order to prevent them? That's all that's required for the court to be satisfied that it's legally entitled to grant an injunction.
Okay.
For a mandatory injunction, what we're talking about, and it's actually not called mandatory in the Act calls it an injunction with a requirement. And what that means is an order that positively forces a person, a defendant, to go and do something. Right. Classically, that would be attend drug rehabilitation clinic or an anger management class. Go and do something positive. And it is often that sort of thing. It's things that are supposed to help them to tackle the causes of their antisocial behaviour. And if that's what you're asking the court to do, there is an additional test. It's in section 3 of the 2014 Act. And it is that the application for the injunction, apart from, of course, setting out what requirement you are asking the court to order, the application must also specify a person. So that could be an individual person or a person within a particular organisation that is going to supervise the defendant's compliance. So that might mean a social worker that supervises their attendance at an anger management course, but it has to be a named person. So that's a very big difference from prohibitory injunctions.
So there seems to be another step involved, at least, in getting an injunction with a requirement as it's put in the Act.
Yeah, I mean, the way that Parliament looked at it and the way that the discussions went in Parliament when this was considered, it was thought that that in practical terms, if you have an order that requires somebody to do something, but there's no supervision, it's pretty toothless. It's not going to happen. And if what you're actually aiming for is an order that really makes the person do that positive step, then you need somebody who is going to be managing that act.
And do you think there's an element of fairness in that as well? Because you're asking someone to actively do something that may be quite difficult for them. And so if you're going to make them do that, it's fair that you have someone there, in some ways, not only supervising, but supporting in a sense.
In practical terms, I think that's right. I mean, let's stray for a moment into practical things. I know that we're going to talk about practical things in a moment once we've covered the law. But, in practical terms, have you ever seen a mandatory injunction applied for?
I've only ever been involved in applying for one out of many injunction applications I've been involved in. So it is much rarer because it's more difficult to get.
And I've had a few, but I've never got them because inevitably the evidence wasn't good enough to show that there was somebody that was going to actually supervise. So the court really takes that supervision requirement very, very seriously.
Yeah.
Okay.
Well, again, sort of practical, but relevant to the legal test. You get the injunction. What people really want to know, or the people being impacted by the injunction usually, is, well, what can I do about the potential that someone may breach the injunction in practice? How can I get the police involved? And of course, you might need a power of arrest for that. But what do you need to actually get a power of arrest? What do you have to show? Right.
So power of arrest is another step up from the basic injunction, because the difference between having a power of arrest on some or all of the elements of the injunction and not having a power of arrest is whether the neighbour can phone the police when something happens and say, please come and arrest the defendant, they're breaching their injunction. If you don't have a power of arrest, there is no option for that to happen. And so in practical terms, the neighbours are left with phoning the housing office preparing a claim to court for breach of the injunction, which is heard weeks later. So in practical terms, the power of arrest is very important. It's what neighbours really want. And the way you get that, again, it's not necessarily too difficult to get, because the legal test in section 4 of the Act is firstly that there has been actual violence or a threatened use of violence. And you might think that doesn't happen that often. And of course, that's true. Certainly actual violence is relatively rare, thankfully. Threats of violence are, of course, less rare. But section 4 also has an additional limb, which is, again, an alternative. You don't have to prove both. You just have to have one or the other, which is much easier to prove than use or threatened use of violence. And that is a significant risk of harm to other persons from the respondent. So not a risk of significant harm. It's important to say, a significant risk of harm. Harm is not fully defined in the Act, but section 20 does say that harm includes physical or non-physical harm. So harm is really even potentially, I've certainly argued this successfully in my cases, harm could be, I cannot sleep because of the noise from the defendant's stereo in the middle of the night, and that means I'm missing work and I'm at risk of losing my job, for example.
Yes.
That is easily enough for a power of arrest because of a significant risk of harm. It does not have to be actual psychological distress. It can be much wider than that.
Although usually you would imagine there probably is a degree of psychological distress in these sorts of cases.
It's not difficult to prove significant risk of harm. Absolutely, it's wide enough. And so if you've also got actual violence or threatened violence, that's even easier, but to get your power of arrest. But even without violence or threatened use of violence, the second limb in section 4, significant risk of harm, is often provable, often easy to deal with.
Yeah, so, and as you said, it's the significant risk rather than the harm, the significance attached to that risk. So that's what it's all about. What's the risk? It may seem like a quite obvious question, because people watching this probably have some involvement with applying for injunctions, but who actually can and who can't apply for this sort of injunction?
Well, there's a sort of shopping list of different organisations, all in section 5 of the 2014 Act. The first two are the only ones that really matter for our housing cases, and that's either a local authority, can always apply, or a housing provider, and that means a housing trust, housing action trust, or registered social provider. So anybody that you or I deal with that is a provider of social housing of any kind is entitled under section 5 of the 2014 Act to apply for an injunction.
But presumably not just a private individual.
But not a private landlord, that's right.
Yes, so that's really the key distinction between.
Yeah, and if a private landlord comes to you and says, I'd like to get an injunction, they'll have to approach their local authority and ask the local authority to do it for them. That's the only way to do it.
Okay, that's interesting. And so imagine you're confident you can meet all of those requirements legally, which should be the starting point, really. Then we're looking at the procedure. Yeah. And what procedurally do you need to do as a starting point for preparing the claim?
So you go to part 65 of the CPR, which has a lot of different things in it, but it has a group of rules around Rule 43 and just a few others following it, which deal specifically with antisocial behaviour injunctions, or Section 1 injunctions as they're called now, under the 2014 Act. And Rule 65.43 and the practice direction basically say you have to issue a claim form, and there is a particular pro forma called N16A, which everybody, I'm sure, watching this webinar is very familiar with. That stands as the claim form for the purposes of Part 65, Rule 65.43, and there has to be supporting evidence with that form. That's it. That's what you have to prepare. Okay,
so what about if you're applying for an injunction without notice, and you're not going to be informing the defendant? Is there anything that you have to do differently in that circumstance?
Well, the most obvious thing is you don't have to serve on the defendant in those circumstances. So normally with Part 65, if you've got an ordinary on-notice injunction, you're going to be serving personally on the defendant, all of the paperwork.
So what do you mean by that?
That means you get, in practical terms, it means you get a process server, somebody who can produce a witness statement to say that they've done this, who goes to the place where the defendant lives or works, where the process server knows they're going to be, and hands the documents to them, rather than, as distinct from, putting them through the letterbox or putting them in the post. So that's personal service, handing it to the person. Obviously, without notice injunctions, you're not going to be serving on the defendant, and in those circumstances, the rules say that the witness statement that you attach to the form has to explain why you are not giving notice. That is in black and white in Part 65, Rule 43, brackets 5. So you've got to include, it would be procedural error not to include in the witness statement an explanation of why you are going without notice.
So it wouldn't just be an issue in terms of persuading the court because you haven't really explained yourself. It would potentially be procedurally incorrect, and arguably you haven't satisfied the requirements of the CPR if you haven't explained that.
Absolutely.
Okay, so that's very clear then. Thanks, Iris.
That's fine. So is that it, do you think? Is that all of the important procedure and all of the important law?
I think in terms of the legal principles, fortunately, they're quite well contained within the Act. That's the nice thing. The starting point is the Act, and
So I really, if I look at sections 1 to 5 of the 2014 Act, I've got most of what I need.
Yes.
And in Part 65.43, I've got the rest. Okay, well, in that case, can I ask you some practical questions, Jamie? Because I think you do an awful lot of this kind of work.
Yes.
And lucky you. And so you can give me some practical pointers. Okay, so I've got a brand new injunction application on my desk, or rather I've got a set of documents that need to be made into an injunction application. what documents am I going to pull together? What am I going to draft?
Okay, so you've touched on it before. You start with the N16A form. That's the starting point, and that guides you really through the first stages. So you need to work out what is it I'm asking for. I'm asking for an injunction prohibiting the defendant from doing something. The N16 form is quite short, so really you generally need that form and you need a draft order setting out what the terms of the injunction you're going to be asking the court for are. You also need the supporting witness statement as well, and the witness statement is the starting point for your evidence. So in terms of the witness statement, that is where the detail of what you're actually asking for and why you're asking for it is contained.
Okay, so you've got a form, the N16A. I think that's a single page, effectively, isn't it? That kind of does really basic things on it, like say the name of the claimant, name of the defendant, the address, that kind of stuff. You've got a draft order that you're going to have as a separate document.
Well, yes, usually what I would suggest doing, and what tends to be the way people would prepare these sorts of cases, is to say in the N16A form, see attached draft order directing the court to the order, so that it can be set out much more clearly and in the amount of detail that's necessary for this sort of case.
And then you've got witness statements.
Yes.
Okay, so let's talk about the witness statements, because am I right? They're quite important.
Well, they're not only important procedurally because you need them, otherwise you can't prove the case, but they are really where you tell the court about the case and why you need this injunction. I think this is probably a good point to say, actually. It's important to remember in this case, unlike a normal claim that you're bringing, where you start off with the pleadings and actually you set out the brief details of the case, at this point you need to have pretty much all the evidence you need in order to obtain the injunction ready to go. And so
before you issue.
So the witness statement is really the main aspect of that. Anything else piggybacks off the witness statement.
Why is that? Why is that so important? Can you not just go to court and say, I would like some more time, please, for more witness evidence?
Well, no. Well, you can, but you won't. That's not really the way of doing things. The best thing to do is to have the witness statement ready, because you want the final injunction at the first hearing, really. You might, in many cases, not have another hearing because you may be serving the defendant personally. It's an on-notice injunction, and the defendant may just not engage. And so there's no need for putting in further information.
And actually that happens quite a lot, doesn't it?
Yes.
I mean, in reality, quite a lot of the time, the defendant doesn't turn up to the first hearing. And so if you've got everything lined up, which you really must do, you will get your injunction, and that'll be the end of it.
Exactly. So that's why really the focus should be on making sure the witness statement is as detailed as possible. However, of course, there's a tension, but there always is, between getting things done appropriately and quickly and showing that actually there is a situation that is urgent enough that it needs to be controlled by an injunction, as opposed to ensuring that things are extremely detailed. But you should always prioritize making sure, as far as possible, that things are detailed, whilst also recognizing you need to act relatively quickly.
Okay, so well, let's sort of break it down a bit. Who's going to give a witness statement in a typical antisocial behaviour case?
So in a typical case, you will always have, or should, generally speaking, have a representative of the housing provider. And that's going to be a housing officer, generally speaking. And they are going to be able to tell you why the housing provider wants the injunction, their own knowledge of the case. In some cases, they will have very good knowledge of the defendant personally. They may have had interactions with them. It may be that the reason for the injunction is something that the defendant has done to them, in which case, that's great. You can detail why the housing provider wants it, the effect of the behaviour and the nature of the behaviour. But quite often, they won't have that information. They'll have some of it. They will have the reasons the housing provider wants the injunction, but they might not have the first-hand evidence of what's actually happened.
So then what do you do? So you've got, okay, so in any case, you want a housing officer, presumably also because the housing officer sort of summarises for the court, this is what's been happening, this is why we're asking for it. If they don't have the first-hand evidence, what other witnesses are you going to have?
I think that's a good way of looking at it. The housing provider provides the overview. They provide the overview of why the application is made and what the detail of the underlying allegations are. But actually, you need, as far as possible, some first-hand evidence.
Okay.
And so then you get into the question of, well, can we get a witness statement from a neighbour, potentially someone who's actually seen the conduct that the defendant has allegedly engaged in firsthand or been a victim of it. Of course, then you have the question of, can we get the neighbour to provide a witness statement? And sometimes they will. I've had quite a few cases where, because of the effect of the behaviour, they're prepared to come to court and give a witness statement. But you could also have a scenario where, for numerous reasons, they're not willing to provide a witness statement. They may
Sorry to interrupt you. There must be a distinction between, okay, I'm willing to put something in writing, but I'm not coming to court. I don't want to see this person in court. They're going to be horrible to me. So what do you do then?
So you may have a scenario where you have an individual who's prepared to give a witness statement but not come to court. In that case, I suppose the way to remedy that is to put the detail into the housing officer's witness statement about why that person's not willing to come to court, but what they've told them, as well as what they're willing to put in their witness statement, and any conversations they've had that give a bit of colour to why, in fact, they don't want to come to court to come and go first.
So that would go into the housing officer's witness statement?
It could go into the housing officer's witness statement. It could also go into their witness statement.
Okay, so let me sort of summarise. You might, in a situation like that where the person isn't willing to come to court, you're going to have what they're willing to say in a witness statement about what happened, first-hand evidence, that important thing about having first-hand evidence of the allegations of what actually happened, when, how it affected me, the neighbour, and all of that.
Correct.
But you might also, in the housing officer's statement, then have a couple of paragraphs that say, here is the witness statement of this neighbour. They have told me that they are too frightened to attend to court, and here are my notes of the meeting where they describe to me how they feel about it. Is that how you'd split it up? You'd have those details in one statement and the details of why they're not willing to come to court in the housing officer's statement. Yes,
that can be a neat way of doing it, but I don't think it would be a problem if you also put in the witness statement from the neighbour that they themselves have. I think it would be helpful if they're willing to do that. It may be that they feel, in fact, that they don't want to make it clear that they're fearful, or they don't want to actually raise any suspicions, but they're prepared to give a witness statement without actually going face to face with the defendant in court. There's then obviously an extension of that scenario where they're willing to give evidence, but only if it's anonymised. And that's usually for similar reasons. They don't want to come up to court or go face to face with the defendant, or they're scared that just simply putting their name to something may lead to reprisals from the defendant.
So if I think about this as to make things easier for me, if I think about it in sort of as a cascade, so the best evidence right up at the top is going to be a witness statement from the neighbour and the neighbour coming to court.
Agreed.
Right. Next best, a proper CPR compliant witness statement with a name of the neighbour, not anonymised, everything exactly the same as in best case scenario, but they're not willing to come to court. And then you'd have the housing officer explain why that is, and maybe even in the neighbour's own witness statement, if they're willing to do it, they might explain why they're not willing to. Next level down, a properly CPR compliant witness statement with a statement of truth signed, but everything anonymised, so that the judge can see the person has actually prepared a witness statement. They're just being given a name, person A, neighbour A, or whatever it is. And then presumably under that, there must be, look, I'm willing to talk to you about this in a meeting with my housing officer, but that's all I'm willing to do. And then the housing officer might produce something that's in the form of a more informal sort of statement. Could that still be valid evidence?
It could, but that's when we get into looking at why, going back to the witness statement. Well, that's about using the housing officer's witness statement to produce the evidence. And so the housing officer can explain, I've had these conversations with the neighbour. They have confirmed to me that all of this detail of what happened, neighbour A or neighbour B, and I exhibit to my witness statement some redacted notes of the conversation that we've had. And you can see, hopefully, if those notes are good, a time and a date and some detail about
they're contemporaneous
notes.
Okay, so that leads me on to another question. So you've said about exhibiting the notes from a meeting. What other sorts of things might a housing officer preparing a statement for an injunction case exhibit?
Okay, so of course, it entirely depends on the nature of the case and the state of the evidence and how long things have been going on. But in some cases, and it's not unusual in these sorts of cases, you will have police reports, and it is obviously prudent for the claimant to be contacting the police to find out whether or not there are any existing investigations that they can be told about, the previous convictions, any reports that may in fact match the allegations that are being made by the housing provider, because quite often these cases will have, as I said at the beginning, a potentially criminal element or an element that leads to complaints of criminal nature. And so the police are always a good source of information for supporting evidence.
Okay.
You may also want, and in fact, certainly if you've got any photographic evidence.
Like what?
Well, you might have, in certain cases, you have evidence of criminal damage, or you may have, but I'm putting the emphasis on damage there rather than the criminal element, but you may have threats that have been written down. Sometimes people will, put something on a piece of paper that's effectively antisocial, put something outside their house, for example, threatening anyone who walks past their door. That could be antisocial behaviour, and a photograph of that could suffice. Video evidence is obviously good. Practically, though, that's always quite difficult to get the court to watch. So if you've got video evidence, fantastic. But then the next stage is thinking, well, can I put this onto a link so the court can just click on it rather than sending them a disc that they can never end up actually watching anyway? So
keep it simple. Get photographs if you can.
If you can get photographs, then fantastic. Again, same sort of thing. Audio recordings that can be played easily are useful.
Okay, so what about, so we've talked about police information, photographs, notes of meetings. What about diary sheets? Are those useful, or is that too much for
so that goes back really to the scenarios where you may have a neighbour who is not prepared to give a formal witness statement, but has kept a diary log of all the incidents that they say have happened. Sending that to the housing officer, having the housing officer exhibit that is again persuasive evidence. Of course, diary sheets from the housing office themselves of any meetings or any incidents that they've recorded, again, very useful.
Do you think there's a distinction, if we're talking about the gathering of evidence by the housing officer, between cases where you've got sort of maybe relatively low-level problems, like say noise nuisance that isn't absolutely awful, but is persistent and is really getting to the neighbours over a long time, versus a sort of one-off, really, really serious, dangerous event? Do you think that the officer's statement looks different?
I think it does, and I think you recognise the two types of case which you tend to be dealing with in these applications: either a one-off, very serious incident, or a pattern of behaviour that's gone on for a long period of time. So dealing then with the first one you mentioned, so the lengthy pattern of behaviour, persistently bad behaviour, but perhaps of a relatively low level. In those circumstances, you want to make sure you've got all of the detail about the dates that each of the events occurred, perhaps one or two sentences explaining what happened, when it happened, and who was there, and detailing as many of those instances as possible.
So particularly if it's repetitive, you can give a good description of the type of behaviour. So noise, amplified music between this sort of time and this sort of time, and then you can list
and then you can list all the dates that happened on. And there'll be scenarios where something slightly different happened, where you might want to give a little bit more information.
And presumably in that sort of case, diary sheets are really good, because rather than hundreds of pages of witness statements, you might summarise things quite shortly in the witness statement and then attach the contemporaneous diary sheets of all of those things.
That's exactly right.
So what about the one-off really serious events?
The one-off really serious events, it's essentially the converse. You don't need all of the dates, because there's only one or two dates to mention. But you need to give the detail about what actually happened and why.
Let me be rude and pause you for a moment. What if there is a history, because this often happens, of low-level problems, and then a really serious thing happens? Should you throw it all in at that point, or can you just focus, should you tactically just focus on the one big event?
Well, there are two ways of looking at it. One is to say you should just focus on the big events because they are serious enough to, in themselves, justify the granting of an injunction. And that's really what you're concerned about. And equally, you've waited until that serious event to make the application for the injunction. So to some extent, that undermines the emphasis on the other incidents, because you've let those pass without making an application, despite them going on
So really, you're going to focus on the serious allegations.
But there is another way of looking at it, which is to say that you might want to just split your witness statement up. You have a section on the serious ones, and you then additionally put a comment under a separate heading to say there have also been several reports between period X and period Y. However, as I said before, those are not going to add a huge amount, because if they really were that serious or justifying you applying for an injunction, you probably would have applied for one by then.
Okay, so I think that makes sense, and that's clear on what the allegations are. And we went through the law earlier, so we know that antisocial behaviour is defined by reference to the effect it has on other people.
Yeah.
So presumably you've got to have evidence about that.
So that's right. So
does that go into the witness statement too?
Absolutely goes into the witness statement, because that really is going to the second part of the test. It has to be just and convenient to prevent someone from doing continuing to behave in an antisocial way, in essence. And the reason that it should be just and convenient, often, or one of the reasons, is because of the effect that it's having on someone. And so you need to explain why it is that this is having a particularly negative effect on the neighbours, on the housing management functions of the claimant who's applying for it. What is it that actually this is causing? Is it making someone's life very unpleasant on a daily basis? Is it making it impossible for the housing providers to just go about and do their jobs, in essence? Or is there something else? Is it making someone extremely upset to the point that actually they're suffering in terms of their health? All of that detail should absolutely go in there, because that's part of addressing the second part of the test. Okay, so we've got, the allegations themselves, the effect they have on the neighbours. What about the power of arrest? We talked about that being about either use or threatened use of violence or significant risk of harm. What does, I mean, do you sort of have a separate bit in the witness statement to deal with that, or have we already covered that just by talking about allegations and effect on neighbours? So my view actually is that where it would be helpful, and it's not something that I actually see that often, I think it would be helpful to address the power of arrest separately. It has a separate section in the Act for a reason. It is different. You can get an injunction, and I've had hearings where you do have an application for both an injunction and power of arrest, and the judge says, actually, no, I'm not giving you the power of arrest. I'll give you the injunction, but you haven't met that test for the power of arrest. Maybe because it
hasn't really been thought about separately and addressed separately.
Yes, right. And I think it's important to say this goes both to the draft order and to the witness statement. So when sometimes I think it can be because these things are prepared in often a little bit of a rush sometimes, because you've got to get the application in whilst it's still of value before time passes, and it can sometimes be the case that the power of arrest can be thrown on at the end, and it can be suggested that it should be tagged onto every single point. But of course, it doesn't necessarily apply to some of the aspects of the injunction, because they are designed.
What should you apply, or what should you ask the court to attach a power of arrest to in your draft order?
So only to those aspects of the injunction that are designed to prevent the things that the power of arrest is designed for. So harm, threats of violence, use of violence.
Right.
You might say, and you could make an argument, that there are aspects that don't involve violence, but in fact they're designed to prevent harm. If you can prove that, fine. They're more difficult from an objective standpoint to show. So if you're able to highlight the points where there's threats of violence, use of violence, or an obvious link to significant risk of harm. Sorry.
Okay. So I think in practical terms, the way in the cases I've dealt with relating to antisocial behaviour, what that translates into is that in your draft order, you start with, again, that cascade principle, you start with the most serious prohibitions. So the prohibition on the threats of violence, or the prohibition on approaching a particular person that has already been assaulted, the most serious. Below that, you might have the prohibition on causing distress, alarm, harassment, alarm, or distress. And sort of at the bottom of the injunction, the last section of the injunction might be the prohibition on causing nuisance and annoyance, or any conduct that is capable of causing nuisance and annoyance. And generally speaking, in my experience, the power of arrest tends not to be attached to that last bit,
right.
The bit about nuisance and annoyance, because judges tend to think that conduct that is capable of causing nuisance and annoyance could potentially be very low level, so much so that it doesn't have a significant risk of harm.
Well, that's right.
So it tends to be attached to everything above nuisance and annoyance. but not nuisance and annoyance.
And I think it's also fair to say that there is a consideration practically from the courts that they don't want to have a scenario where someone is being arrested for shouting a little bit loudly one day and not really causing a huge amount of harm, but actually there's so much of a background there that the people whom the complaints were made initially and the underlying reason that there is an injunction, see this person shouting, call the police, that person gets arrested, they come to court, you have a hearing, that person gets let, the defendant gets let off anyway, and it's a resource issue again. So I think they'll only want to really attach a power of arrest to the aspects where the test really is met, because then there's proper use of the
proportionate,
to have the police involved and to then have the court have another hearing to deal with it.
I mean, certainly in my experience, judges just don't like attaching powers of arrest to nuisance and annoyance clauses in injunctions. But they will attach powers of arrest to other clauses,
absolutely,
including exclusions from particular areas, or prohibitions on approaching a particular person, or the sort of threats. Of course, the harassment, alarm, or distress, threats of violence level prohibitions.
So just dealing with the power of arrest, I would say it's worthwhile addressing that separately in the witness statement if you can, for the same reason. And that also goes to the exclusion order that you just mentioned. If you're going to have an exclusion order, from the draft order perspective, you obviously need a map and you need to show exactly where that order is. And that goes back to the detail, highlighting clearly what the defendant is actually prevented from doing or where they're prevented from going, and not using vague phrases, for example, like the vicinity of the area.
So this is drafting the order.
Yeah.
So what you're doing is you're drafting the injunction for the court.
Yes.
By preparing the draft order. And the key thing to think about when you're doing the drafting is clarity, right? Because the one thing the judge will come back to you on, if they're not happy with you, is a lack of clarity in the drafting of the order. So if you're going to spend time on anything, spend it on drafting the order. Is if you do it right, the judge will just give you everything you've put into the order. So maps, when you're applying an exclusion area, so it's very clear what area it is, try and avoid things like the vicinity of or the locality of, because it may not be clear what that means.
And the defendant might not understand.
And the defendant, well, that's the other thing, isn't it? You've got to think about it being a document that the defendant can understand. That's important as well. Okay, so I think final point for this session, broad question, important question. What do you do in this, because this is going to be in the statement, what do you do in the statement about telling the court about what you know about the defendant? So, for example, they might have young children.
Yes.
They might have mental health problems, or you might think it's possible they have mental health problems. Do you just leave that out because the defendant can sort that out when they come to court? They can tell the court about it, or do you front that up and talk about it in the witness evidence?
So obviously today we're focusing really on practical things about preparing the papers. So without getting into the detail of all the potential legal implications of all those things, I think it's fair to say that as a blanket rule, you should address those points. Because if you don't address them and they come up, that's going to look quite bad, and the court's going to be concerned about granting an injunction in the circumstances where you've missed out something potentially relevant. It may be that the housing providers don't know very much information about someone's mental health, but they have a suspicion perhaps there may be mental health issues. The thing to do in those circumstances is check the records, see what information there is there, and provide the information. It might be that the witness statement has a paragraph saying, I've had a look at the records, we have some record of the defendant making contact with one of the multi-agency providers, but we don't know anything more than that. And I've tried to contact him and I've not had any success. And that could be enough, as long as it's been looked at. Of course, again, it depends on what the information available is. But I think the important thing is to address it and to put that down on paper. And if you don't know, just say you don't know.
And not least because if it turns out later on that they do have mental health problems, something that is very, very common with injunctions, and it turns out that those mental health problems are long-standing enough to make their mental health a disability, then you're going to have to explain, very likely at some point in the future, why the step you took was proportionate to the situation. And if you've already thought about that as best you can, investigated it, looked at what the situation is, and taken your best possible view based on the information you were able to get about what could be done to assist this person prior to going for an injunction, then you are front-ending, showing the court that you've considered proportionality properly, and you've got a much better chance of having a compliant, non-discriminatory injunction, rather than everything falling apart at a later point when the defendant gets solicitors and they raise the issues of disability later on.
What you're essentially saying is that using the public sector equality duty framework, you think about those sorts of things, albeit it may be dependent on how much information you have in terms of how much detail you go into in terms of the specific aspects that relate to that person, but thinking about what you could have done differently in terms of approach instead of applying for an injunction. And that then also feeds in to the overall just and convenience test. Why is the injunction the step that you've required? Well, why do we need the court to grant one? Why couldn't we just have had a meeting where we had a mediation between the individual who is complaining about the defendant and the dependent? Or why weren't they responding to letters?
And in those just to finish that point, in those first types of case that we talked about earlier, where there's a long history of low-level problems, that's much more likely to be necessary, isn't it?
Yes.
You're going to be much more criticised for not engaging in the prospect of mediation, in social services, helping that defendant in other steps short of an injunction. You're going to be criticised for not doing those things much more than if you've got a one-off, highly violent, highly frightening event that has caused such immediate problems and such harm to the neighbours that actually you've looked at all other options and this is the only realistic option.
Absolutely, I think that's right. I think that where, as you say, where you have persistent pattern of low-level behaviour, you need to be showing why it is other steps haven't worked first and why this is really the last resort.
And what about capacity? Because capacity is a different thing from disability. Lots of people are disabled and have capacity. You know, capacity is about being able to make decisions or not, whereas disability is about impairments much more generally. And conversely, somebody may have a momentary, a crisis that leads them to lose mental capacity, but it's very short-lived, and because it's less than 12 months, it's not a disability. So capacity is different from disability. Different. What do you do if you are a housing provider and you think there's a possibility the person lacks capacity?
Well, I think that's it is tricky because of course, if you are concerned about capacity, the thing to say again is you want to address that. Yeah. But what you have to remember is that there is, of course, a presumption that someone does have capacity in these circumstances, but it should be done, I think, really much in the same way as dealing with the equality issues. You should raise it within the witness statement and say, we don't believe if this is the case. Of course, if you actually believe or have a suspicion more likely than not that someone doesn't have capacity, that's a different issue.
Well, then you can't have you can't go for an injunction, can you? Because there's lots of case law that says that if a person lacks capacity to either to understand, or even if they do understand, to comply with the injunction, the court must not grant the injunction. So actually, if there's any question of capacity, you have to look at it quite carefully before you go forward with drafting.
So that's why I'm thinking that really you're talking about a scenario where you don't actually suspect someone lacks capacity, but you are recognising, in fact, there may be a potential issue where this could be raised.
And then you mention it. And you say you don't consider it's an issue and there is a presumption of capacity, but you're aware of this and that note in the file and you're letting the court know about it.
Absolutely. And that's also really important because a lot of these cases are, at least in the first instance, dealing with people who are going to be listening in person. So you obviously have a duty to them and to the court to put forward the points that are relevant. Exactly.
Okay. Well, should we summarise, Jane? I think we're nearly there, aren't we? So let's see where we've got to.
Okay.
So we've got the law relating to antisocial behaviour injunctions set out in, broadly speaking, in sections 1 to 7 of the Antisocial Behaviour Crime and Policing Act 2014. We've got applications under Part 65, and those are made by a nice, simple pro forma called an N16A, one-page document, supported by, in almost every case, unless it's the most simple of cases, very rare, most cases, a separate draft order, which you've thought about carefully, which sets out what you want the injunction to say fully, plus supporting witness evidence, at a minimum a housing officer, and most probably also at least one neighbour who has direct first-hand evidence to give to the court about the allegations that form the basis of the injunction.
Yes, I agree with that, and that's the key. Those are the key points in terms of preparing the application and issuing it. And then you have to think about the detail, which is what we were talking about before, and making sure that actually the allegations have been set out in a very clear fashion within the witness statement, and the draft order makes sense and can be easily followed both by the court and by the person against whom you're asking for an injunction to be made.
So I guess at the end of all of this, when you've done your drafting, you're going to step back, look at what you've prepared and say, will the judge reading this understand why I'm asking for this injunction? Yes. Understand why I think it amounts to antisocial behaviour, why I think that this injunction is just and convenient to stop the antisocial behaviour, and if I'm asking for a power of arrest, understand why I say there's either violence or threats to violence or a significant risk of harm. And I've got to cover all of those things because the judge should be asking all of those questions when he or she reads the paperwork.
That's right. Exactly.
Well, that sounds easy. Excellent. And I think we're going to do another webinar, or our colleagues will be doing another webinar next month about the next stage of the process, preparing antisocial behaviour cases for hearing. So I look forward to finding out what the next steps are in our hypothetical antisocial behaviour case. Very nice to talk to you, Jamie.
Good to talk to you too, Iris.
Thanks. Bye.